We've got some serious movement on the legal front when it comes to defending our Second Amendment freedoms. A coalition made up of the Department of Justice, Attorney General Bondi, over 24 states, and several major pro-gun groups has just thrown their support behind a lawsuit challenging statewide bans on concealed carry. That case is now scheduled to go before the Supreme Court for conference as the new term kicks off this fall. So let's walk through exactly what's unfolding. If you live in places like New York, California, Hawaii, New Jersey, or any state trying to strangle your right to carry concealed, this one's for you. The lawsuit in question, Wolford versus Lopez, comes out of Hawaii and is seeking emergency action from the highest court in the land. At the heart of it is the Ninth Circuit's approval of sweeping default no-carry rules for all private property. In short, the state wants to presume firearms are banned everywhere unless an owner explicitly says otherwise, and somehow argues this fits under the Second Amendment. What shocked a lot of folks recently is that the Department of Justice and Attorney General Bondi aren't standing on the sidelines this time. Instead, they've stepped into the ring with a formal amicus brief urging the Supreme Court to take up the case. In that brief, they argue that this is the moment for the court to confront how lower courts have been sidestepping and outright defying the Brewing ruling. They're also warning that if this case isn't addressed, the same type of legal gymnastics will keep happening, especially with proposed bans on rifles and standard capacity magazines waiting in the wings. This show of support has grown fast. We're now looking at support from 25 states that back the Second Amendment, plus multiple constitutional rights organizations, all joining the charge. That case is now on the docket for Supreme Court conference this coming September, right at the beginning of the new session. So what exactly triggered this legal fight? Well, after the Brewing decision reaffirmed that carrying a firearm outside the home is a core right, Hawaii responded with a law called Act 52. Rather than comply with the spirit of Brewing, they doubled down with more restrictions. Under Act 52, citizens can't carry on private property unless the property owner gives you direct permission. Keep in mind Hawaii already had some of the toughest carry laws in the country. In nearly 2 decades, the entire state handed out barely a handful of permits, and in one county, not a single one. Fed up with the overreach, the plaintiffs, supported by gun rights organizations, filed suit against the state. And in a surprising move, a district court judge agreed with the plaintiffs. That judge issued a temporary restraining order that was later turned into a preliminary injunction, ruling that the blanket private property carry ban likely violated the Second Amendment and didn't hold up when measured against the precedent set by Brewing. The state didn't back down. They appealed to the Ninth Circuit, which sided with Hawaii and overturned the injunction. In their opinion, the Ninth Circuit leaned on century-old hunting laws on private land as justification for the new carry restrictions, an argument that's frankly a stretch. After that, the plaintiffs pushed for an en banc rehearing, hoping the full panel of judges would take another look. That request was denied. In a sharp dissent, Judge Van Dyke called out the court's decision, saying that denying review was just another way of downgrading the Second Amendment to second-class status. His criticism echoed what many gun owners have been feeling for years, that some courts treat the Second like it's optional. Now that frustration is turning into action. The case is officially heading to Supreme Court conference in the early part of the next term. If the court grants certiorari, it could trigger a major ruling that forces states to comply with Brewing and respect the fundamental right to carry for self-defense. This one's worth watching. Whether you carry a full-size .45 ACP or a compact chambered in 9mm, Your right to bear arms outside the home is on the line. Let us know what you think in the comments. Do you live in one of the states affected by this? What would a win here mean for you? Tap like, share this with your fellow shooters, and subscribe so you don't miss the next big Second Amendment update. And as always, stay armed, stay informed, and stay free. This case has a steep hill to climb when it comes to securing Supreme Court review, mainly because it's still sitting at the preliminary injunction stage. Historically, the Supreme Court has declined to take up most Second Amendment-related cases at this point in the legal process. But now, with the full backing of the United States Department of Justice, the odds are looking a little better. In a recently filed amicus brief, the DOJ made it clear the near-total restriction being challenged here goes directly against what the court laid out in Brewing and contradicts the deeper American historical tradition of the right to bear arms. The DOJ emphasized that the Brewing decision recognized a fundamental right, that average, law-abiding citizens have a broad constitutional guarantee to carry firearms for personal defense in public. What's particularly fascinating here is that the Trump-era DOJ is urging the Supreme Court to take up this case now, even though it's still at a relatively early stage. Normally, the court avoids these kinds of interlocutory appeals, but the administration is pushing back against that pattern. Their argument? Hawaii already admitted during earlier proceedings that nothing else needs to be hashed out at the district court level. That's a key point. If both parties agree the facts are settled, then the court has no reason to wait. As expected, Hawaii took the typical anti-gun state approach. They argued that the case is premature, that no circuit split exists, and that the lower court should be allowed to fully address the issue. They also tried to downplay the federal government's support, dismissing the DOJ as an outsider with no bearing on the outcome. Hawaii insisted the case wasn't ready and that the record still needed to be developed more thoroughly. But here's the twist: Hawaii's own words may come back to bite them. In the response brief filed by Mr. Wolford, the plaintiffs point out that Hawaii is contradicting itself. When asked directly during oral arguments at the Ninth Circuit what was left for the lower court to resolve, Hawaii's counsel flat out admitted, "We think that there isn't anything. We think at the end of the day that these are not Second Amendment violations." That's not just an offhand comment, that's a judicial admission. And now it's front and center at the Supreme Court. The plaintiffs also took issue with Hawaii's historical defense of its so-called catch-all ban. Hawaii argued that because it's restricted carry rights since the 1850s, its approach should be considered constitutional. But the response brief slammed that logic, pointing out that a single state's outlier practices cannot override the constitutional framework rooted in the founding era. To quote their wording, Hawaii seriously errs in contending that because it has limited the carry of weapons in public spaces since at least 1852, its default rule is constitutional. That assertion is self-evidently frivolous. So, in trying to keep this case buried in lower court proceedings, Hawaii may have actually boxed itself into a corner. Their own statements before the Ninth Circuit show they believe no further factual development is necessary yet. Now, they're arguing the exact opposite to delay Supreme Court involvement. With the Department of Justice weighing in, this case has serious momentum, and it's officially on the Supreme Court's calendar for conference on September 29th. As the new Supreme Court term kicks off, the justices will consider whether to take this case and tackle the issue of statewide concealed carry bans head-on. The added support from the federal government could be the tipping point, especially given the clear defiance of brewing by lower courts and several states. We'll have to wait and see how it all plays out, but this could be a major turning point in the national fight for concealed carry rights. If you're following this closely and want to support the channel, make sure you hit that subscribe button. Also, check out our free legal survival guide. It's a downloadable PDF packed with useful information to help gun owners stay on the right side of the law, especially in places like California and Hawaii that are constantly testing the limits of our rights. It's not legal advice, just practical info, and all you need to do is enter your email to get it sent straight to your inbox. Thanks again for sticking with us. Remember, this country wasn't just founded by farmers and soldiers, it was built and defended by armed thinkers. And it'll be preserved by them too. Stay sharp, stay free, and as always, stay armed.